Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is an attorney, William Mahan. Bill has his law offices today in Campbell, soon in San Jose. He's been practicing law for 30 years. Bill has a master's in taxation degree from Golden Gate University and a JD, which is a law degree, from Santa Clara University. And his practice focuses on estate planning and probate and business planning and real estate. And today, Bill and I are going to be talking about tax considerations for short sales and foreclosures, and maybe a little bit about loan modifications too. So before we get started, we want to give you a caution, and that is that this is a complex area and this is only an introduction, and we want you to seek legal and tax advice, and we hope this will just be the beginning of a continuing conversation that you're going to have with your own advisor. So with that, Bill, thanks a lot for joining me today.
Thank you.
And so let's go ahead and get into some of our questions. So first of all, what are some tax consequences related to loan modifications?
Well, loan modification is when a borrower goes back to a lender and wants to modify the terms of the loan. And so the kinds of things you would modify would be the length of the loan, the interest rate, or maybe the principal amount. The primary area where tax consequences are going to arise is in the area of principal reduction, because that is debt relief, and debt relief generates income tax. And so, you know, it's not, even if it was non-recourse financing, you're not really dealing with it as that kind of mortgage. You're just asking for a modification of terms. So I think the tax consequences from a reduction in principal would be a tax consequence, the income tax consequence that would have to be looked at, and then, you know, once you've calculated what that's going to mean, you know, look and see if there's some way you can get a relief from that kind of taxation.
Is there an exclusion that may apply?
Right.
So we may talk a little bit about some of those here shortly. Should be. Okay, well, refresh our memory, because we're going to be talking a bit about recourse debt and non-recourse debt. And we actually had another interview where we talked a little bit about legal considerations about these. So folks, you can find those at our website, which is www.financialinsiderweekly.com under past episodes. So, again, what is recourse debt? What's non-recourse? And are the rules consistent among the states?
Okay, well, non-recourse debt in the context of personal residences, single-family homes, it really is based on state law. In other words, most of these mortgages are not going to say that they're non-recourse or they're recourse. They don't have those kinds of wording. So you have to look to state law to figure out whether or not there's an anti-deficiency statute. And the anti-deficiency statute results in what's called non-recourse debt. So for example, in California, it would be for purchase money for a personal residence that somebody buys to live in. That purchase money is protected under the anti-deficiency statute, which means the lender cannot pursue the borrower for any deficiency if the property is worth less than the amount of the mortgage, and therefore it's quote-unquote non-recourse. Recourse debt is everything else. It's debt that, for one reason or another, the lender could pursue a deficiency against the borrower if the property is lost for less than the amount of the mortgage. So in California, again, if you buy a property and you meet all the qualifications for the anti-deficiency protection, you can lose that and make it into recourse financing by refinancing.
Yes.
Or by taking out an additional mortgage like a home equity line of credit later, and that is a recourse debt as opposed to non-recourse.
Okay. Okay, so our second and third mortgages for purchasing a principal residence non-recourse. So this is, again, we're talking about the original purchase of the property. Occasionally they have additional financing that they've had to have 100% financing.
Right, a lot of them were put together that way, particularly a lot of them in recent years with a first mortgage and a home equity line of credit. but it's all really purchase money.
Yes.
And in that case, they're all bundled under the anti-deficiency statute. If you meet the requirements of you bought it to live in and it was purchase money, there could be 2 mortgages, even usually not 3, but usually at least 2. That was very common, but they would both be non-recourse.
Okay. All right, so here's one of our curveballs. What happens if investment property is held in an LLC?
Well, if it's investment property, that means it's not your personal residence.
Right.
So the question is, what are the tax consequences to owning it?
Yes.
Well, you're going to have essentially recourse financing in an LLC because it's not going to qualify under the anti-deficiency statute, as I just said. So the tax consequences are going to depend upon, again, if the property is foreclosed for less than the value of the property, there's going to be a tax consequence. And you're not going to qualify under other statutory protection for debt relief. And so there's potentially going to be a tax consequence. Now, because it's in an entity, the question would be who's responsible for the tax, the entity or the individual. And I would say that, most of the time you'll see that lenders are going to make the principals of an LLC guarantee the debt, and when that happens, then they're going to have liability for that debt, and if the debt's forgiven, they're going to probably have tax consequences.
So this is a big question mark in a sense, so I guess I'll make a little comment here, and that is that the LLC in a sense is providing a shell to sort of make the non-recourse related to the investors. If they make a guarantee, like you said, then obviously they've signed on their recourse.
Right.
There are a number of investment property type transactions that are structured in such a way to make, and usually quite often by agreement with the lenders, to make the loan non-recourse.
Right.
So you really have to get into the facts of the case, I guess, is what we're getting down to here.
In that case, what happens is sometimes for a period of time they'll be recourse and then they become non-recourse. There's all different ways of structuring them.
Yes.
But once they become, if they are non-recourse, it'll be in the wording of the documents as opposed to being under the statutory law.
Yes.
And then the consequences will, depend. There are cases that would say that if it is non-recourse financing and it is foreclosed or short sale or whatever else, it's treated as non-recourse financing, and that means there's not going to be an income tax consequence.
Yeah. Well, there is an income tax consequence. However, it's treated as a sale for the amount of the mortgage. So
well, there also could be gain on the transaction. We have to be careful when we say no tax consequence because there's 2 types of income possible. One is gain on the transaction, and the other is ordinary income from debt relief. And so in any transaction, you have to look at both to see if there's a tax.
In most cases, if the loan is related to the purchase of the property, then you're going to have a sale for the amount of the loan, which is going to be something less than or equal to or less than the purchase price. And so in most cases, there won't be a gain.
Right.
Although we could have depreciation and other things that can affect.
Basis.
Yeah. Okay, so let's see here. What's the tax consequence of a deed of trust sale of a non-recourse debt? So in a sense, it follows a little bit of what we were just saying.
Right. Well, a deed of trust